All right, what's going on? I want everybody to have a good Monday. I wanted to go over some of the things that I was bringing up on Instagram, and I want to heighten people's understanding of what's going on in regards to so-called loans. There are no loans, okay? You're in an investment contract. Some people think that a security is, they're reading the case law in regards to what proves that a security is a security, okay? They believe that a security is something that is over 9 months. No, a security can be securitized from its inception. Okay. So when I did the video talking about servicing agreements, and that's really what you're doing. You're delegating when you're signing a lease or when you're signing a contract, it's like you're delegating your authority, or you're like signing a will, a living will, how you want the payments from the lease agreement to be distributed over time, and you're giving them the lease through a servicing agreement. Okay, so that's why I'm bringing this up to you, so you have a greater understanding of what's going on, opposed to what people believe is going on. Okay, just like I said, when you do a promissory note, a draft, or whatever, that is actually, it is a deposit agreement. So so we'll get into what a servicing agreement is. So a servicing agreement is a contract between a servicer, okay, the party that's typically the asset originator, seller, or related firm who is responsible for collecting payments on pooled assets and remitting them to the securitization special purpose vehicle. So someone tried to tell me I don't know what I'm talking about when I'm talking about where your payments go, or when I'm talking about mortgages, when I have more mortgage knowledge in my pinky finger than they have in a whole lifetime. So, and a special purpose vehicle, SPV. If you hear me use these terms, I'm talking about a special purpose vehicle. An account can be a special purpose vehicle. Um, a pooling and servicing agreement can be a special purpose vehicle. A trust can be a special purpose vehicle, or an assignee. So it doesn't just have to be a special purpose vehicle. By you signing a lease, or signing a note, or signing an agreement, you assigned your rights to the bank, not fully, but you gave a certain delegation to where you have to have a specific performance in regards to the lease, because you haven't signed off your liability. Okay, the assigned party whom's rights in a contractual agreement and or an asset have been transferred and assigned. Okay, you haven't fully assigned your rights, but by signing it, you agreed to the terms that are in the lease or the contract, okay, under which the servicer is responsible for administrating a lease and acting as a conduit for all payments over the lease term in return for a periodic servicing fee. Okay, so when you're paying a mortgage company, they're only entitled to the fee. They're not entitled to the principal and the interest. Didn't know that, did you? The duties and authority delegated to the servicer and the servicing fee are subject to negotiation, and commonly include customer service, lease payment, collection and processing, collection actions, lease default management, and collateral liquidation. Pursuant to the servicing agreement, the servicer is typically authorized to inspect the leased assets, review the financial statements and other information of the lessee and any guarantor on periodic basis. See, this is why you have a credit card and they'll ask you to update your income, because you don't even know this is going on. Bill the lessee for and collect the amounts due under the lease agreement, and enforce the lessor's default rights and remedies with respect to the lease documents and the lease assets in the event the lessee default of a lessee default. Where leases and securitized, the special purpose vehicle typically enters into the servicing agreement with the lessor as the servicer. The lessor remains responsible for the continued collection of interest and principal payments from the leases originated by the lessor, i.e., lease receivables, and for their remittance to the account maintained on behalf of the SPV. See, they're holding you liable to an agreement that you didn't even sign. You didn't sign an agreement with the special purpose vehicle. You signed a promissory note with the servicer, okay? Because it controls the collection policy, the servicer can significantly affect the cash flows in the transaction. For asset securitization, a backup server may be appointed to act as the servicer in the event of the original servicer's failure to perform or insolvency, in order to mitigate the risk of disruption in servicing of the underlying assets. Now, when you look at this right here, this breaks down the structure of a lease agreement. So you get the lease vehicles, the lease payments go to the servicer pays to the collection account, and it goes to the reserve account. Any excess funds goes to the certificate holders or note holders, right? So how is there excess funds on an account? By fees, charging excess of interest, and some of the interest is probably in a subsequent agreement. So where they're saying on your note you owe 6%, well, on the back end it might be 12%. So I wanted to share this with you because when you're signing contracts, right, the servicer is not who you think. They're not the owner of the account. They don't own the account. So what they're doing is they're doing a collection attempt or activity. It is due to misrepresentation, because when you signed for an alleged loan, you didn't agree to all of this. You didn't know all of this was taking place. So they didn't disclose it to you. So how can you perform when the information wasn't disclosed to you? And with that being said, I'm out.